non-adversarial nature of Social Security Disability Adjudication. Social Security Administration, also referred to as SSA, doesn't operate like a traditional courtroom. Its administrative review process is explicitly designed to be non-adversarial, at least that's what they call it. Unlike the traditional American court system that you probably see on TV with Law and Order and such, where opposing attorneys sort of battle to present their case, no attorney stands as SSA's adversary during the initial phases of a disability claim. Only much later, if an appeal reaches federal court, would an attorney represent the government's interest. Administrative law judges, also referred to as ALJs, are at the heart of this process. They function like magistrates in inquisitorial systems, actively seeking facts, gathering evidence, and questioning witnesses. In 2000, the Supreme Court affirmed that Social Security hearings are inquisitorial rather than adversarial. At least that's what it says on paper, underscoring the ALJ's responsibility to thoroughly investigate and develop arguments supporting or denying benefits claims. During a hearing, the ALJ is supposed to delve into all aspects of the case, questioning the claimant and witnesses, evaluating evidence, and ultimately, they are supposed to decide the outcome based on the preponderance of the evidence standard. Now, why this system works and arguably doesn't work. While far from perfect, this informal, non-adversarial setup arguably yields more accurate disability determinations than a purely adversarial model might. Maybe compare it to the workers' compensation system. In many ways, SSA's approach presents a much fairer alternative. However, claimants have faced an increasingly tough landscape in recent years. ALJ approval rates have fallen from around 60% to 40% within the past decade. We even have one local ALJ that has approved around 14% of claims, 14% of claims, much less than 20%, about 1 in 6, I guess, if you do the math. Actually, less than that. But newer ALJs often come with a predisposition to be suspicious of claimants, their doctors, and their representatives. Many seem to prioritize preventing fraud, or at least that's their excuse, over ensuring benefits reach for the truly disabled. Some claimants themselves even express the same sentiment. They might see themselves as genuinely disabled, but harbor doubts about others that are on the disability rolls. This hostile adjudicative climate, as termed by SSA long ago, remains a significant hurdle for claimants. Despite these challenges, the Social Security regulations governing disability determinations have an internal logic promoting sound decision-making. The sequential evaluation process breaks the determination into steps. Each is supposed to be answered without consideration of a predetermined outcome. However, when decision makers abandon this process in favor of what we call a results-oriented conclusions, the results behind their findings often become shaky, inconsistent, sometimes even ludicrous. What we mean by predetermined outcome or results-oriented conclusions is where they decide the outcome and then make the facts, or at least attempt to make the facts match the outcome. Not uncommon in both adversarial and non-adversarial systems. And unfortunately, we're seeing a lot of that in the SSA realm. Now, the challenge of adverse evidence. This is a problem to some degree. Traditional adversarial training can make attorneys reluctant to submit evidence that hurts their client's case. However, Social Security regulations really don't allow for this. All evidence, all being all capital letters, all evidence relating to the claimant's disability must be submitted. This frequently includes adverse findings from workers' compensation evaluators, routine medical treatment, and even reports that the representative themselves may have requested. Even if you obtain a medical opinion that works against your case, you have to submit it. And don't be surprised if your attorney submits it. That's what they're supposed to do, because if they don't, SSA is going to find out about it. Even before all the records are electronic, now they're all electronic, but even before they would find out about it, go get the record, find out you did submit it, and then now you have sanction issues with the Social Security Administration. Navigating this complex and challenging system and changing system can be very daunting. If you have any questions about this issue or any other disability matter, we're happy to help. Give us a call or reach out at cliffcarlsonlaw.com.